May it please Your Honour, I appear on behalf of the defendant in this matter, and the learned Mr. Montague Smith QC appears for the claimants, or the claimant, I should add. Your Honour, there are a couple of housekeeping points which perhaps before we get going I should deal with. Firstly, there is a second witness statement of Stephen Meister, which I don't believe is objected to by the claimant, which should have found its way into the papers before you. That simply updates the position as to what is going on in New York. I think the claimant's witness and Mr. Montague Smith and his skeleton make the point that we haven't applied for a stay of enforcement or execution in New York. That has actually been done and was done on the 20th of January, and that is what the second witness statement of Stephen Meister deals with. And he exhibits the memorandum of law in support of that application. Your Honour, there is also the issue of, you may recall that the claimant in Mr. Feinstein's witness statement states that the last stand participation agreement and the representation agreement are confidential documents. And we are quite happy for this court to redact any reference to those documents or to treat them in such a way as they cannot be identified by the public in any judgment that it issues. So I just state that.
Well, I need to remind you about that in the course of the hearing, if necessary, certainly at the end of the hearing.
Of course.
Yes?
Your Honour, I think that is it for housekeeping, unless
I wonder if you could bring me up to date on what's going on in the various jurisdictions that proceedings have been taken to enforce the judgment. And in particular in London, what's the state of play in London?
in London there is a hearing scheduled for the 8th and the 9th of March, in which both the jurisdiction application and the summary judgment application will be heard together. That is following an agreement between the parties that they will be heard on the same occasion, as opposed to an order of the court. And we don't know who the judge will be. No.
Now, I have had access indirectly through some of the witnesses to what is being submitted.
Your Honour, yes.
Clearly, the jurisdiction is going to be different from what arises in this case. Otherwise, are the issues in effect identical?
They are, and as for the jurisdiction issue, the only distinct issue in this court is the constitutional issue. The other jurisdiction issues arise in London, much as they do here.
Well, what other jurisdiction issues is there?
Well,
other than your point that this is something not permitted under constitutional arrangements of the UK.
well, Your Honour, there is a difference of opinion between myself and my learned friend as to whether or not the issue of whether a judgment is final and conclusive on the merits goes to jurisdiction or as a defence to the substantive claim for enforcement.
At the moment, if it matters, I'm inclined to believe it's not a jurisdiction matter, but I don't think it matters whether it is or it isn't really.
But
it's a distinct issue and it's going to be dealt with.
Your Honour, yes. But that is the argument, the same argument is put in London on a jurisdictional basis there as well.
And it's also said the arguments you make here concerning the term sheet and the alleged inappropriateness of relying on the affidavit of confession are round numbers as well.
They are, and they are the substance, the heart of the proceedings in New York as well. And really those issues of New York law, which we say that this court should not preempt the decision of the New York court on, or indeed London should not preempt that decision either. The position in New York is that, as I understand it, and I don't mean to be giving evidence, but I think this is not controversial, the motions have been listed to be heard now on the 29th of March. So there has been various delay that has been down to the court in New York enlisting those motions to be heard. It was originally hoped that argument could be heard on those motions on, I believe, the 8th of February, because they were due to be submitted.
Now on the 29th, I read some of that, something that suggested that there would be some months before a decision was had.
Well, Your Honour, that is simply the opinion of our New York lawyers. How long the New York court actually takes to hand down a decision is entirely a matter for it. It will have not just these two motions to deal with, but also an application to quash the subpoenas that have been issued by way of enforcement in New York. So it may be that it will take some time to...
Yes. Well, thank you for that update. Elsewhere,
I believe the only hearing that has occurred has been in, I think in Cayman, where there was an application for a summary judgment heard. There was no contested jurisdiction of the Cayman court because EGFL is domiciled in Cayman, so it couldn't contest that jurisdiction. There, the judge, as I understand it, has indicated that she's reserved judgment, and I believe so, yes. And the indication is that the parties should update the court on what is occurring in New York until that judgment is issued. Whether or not it will be issued before proceedings in New York are concluded is... Your Honour, yes. But the same applications have been made there as have been made here for a stay of the proceedings pending the...
Yes, I understand. But otherwise, the other jurisdictions, I forget where they are, a few more. Is the position that there's been no substantive hearing?
I believe there's been a substantive hearing in Delaware as well, which in Delaware the application was to, I believe it was effectively an application based on the 5015 in New York. And what happened in Delaware was that execution was stayed by a month. And I don't know what's happened since then. That was back in January. So execution was stayed until, I think, around the 13th of February. I'm not sure what's occurred since then.
Thank you very much.
But there's been no hearing in the BVI as yet.
Now, I think the two of you agree you should show us.
Your Honour, yes.
Until I hear any convincing arguments of the contrary, I think the best course is that you make your submissions on all the issues in the case, without breaking off the summary judgment application and then responding to that.
Yes, Your Honour.
And then I'll hear what you say. And to the extent that either of you wishes to and is entitled to reply on those matters where you are, in effect, responding to, then of course I'll hear you in reply.
I'm content with that, Your Honour.
Thank you very much. Well then, I have had a chance to do a certain amount of reading, so you will bear that in mind as you make a decision.
Your Honour, yes.
2 days seems to be ample.
Yes. I think we'll go beyond 1 day, but we certainly shouldn't take 2 days. Your Honour, you'll have seen from my skeleton, and I won't take you to the applications or to the particulars of claim or pleadings, but this is the jurisdictional application is based on 2 grounds. One is a constitutional argument, and the argument, Your Honour, is quite simply put. It is that Article 120 of the UAE Constitution reserves for the exclusive legislative and executive jurisdiction of the UAE Federation all matters of foreign affairs. This is an argument that really is about the interpretation of the UAE Constitution. And it's important to appreciate that point, because the UAE Constitution is obviously the constitution of a civil law state, and it would be interpreted by the Union Supreme Court wearing civil law spectacles. So the arguments from the point of view of the DIFC Court as to the interpretation of the Constitution as a matter of DIFC law or otherwise are not really relevant to our submission. We say that if it is arguable or it is persuasive that foreign affairs, as used in the UAE Constitution, if that expression is sufficient to encompass the recognition and enforcement of foreign judgments, then it must follow that the DIFC Court cannot have any jurisdiction to deal with those matters, because the legislation that has conferred that jurisdiction, and the jurisdiction of the DIFC Court is entirely statutory, is based on that legislation, Article 7 of the Judicial Authority Law and Article 5. That legislation is, by definition, unconstitutional. It's trampling on the exclusive legislative jurisdiction of the Federation. If that legislation falls away, then the DIFC Court simply has no jurisdiction. And this is a point that, as we say, it's really an issue of the interpretation of the Constitution. But to that extent, the arguments made on a learned friend don't really join with that point at all. Because my learned friend says that he lists them in his skeleton, that we are making an argument that is contrary to binding authority in this court. But of course, this argument has not been tested by this court, has never been raised in this court before, and there is no decision on this particular argument. To that extent, there is no binding authority on this particular point. So,
somewhat surprising position, given the fact that the Court of Appeal, the DIFC, has said that it has jurisdiction to the courts of the DIFC have jurisdiction to enforce a foreign judgment. In that case, in English law.
well, yes, yes, but it wasn't, that decision was reached not having heard this particular point. So on this particular point,
you say I have jurisdiction to bypass that decision because of Carl's list.
well, so, Your Honour, I say that you have jurisdiction to refer the matter to the Union Supreme Court for its determination on the point, regardless of the DNB case and the Court of Appeal's determination that it has jurisdiction to enforce foreign judgments, because that is a separate issue, really, from this argument. And we say that that decision cannot bind Your Honour in respect of this particular argument, which is not decided in that case at all. The next point that's made by my learned friend is that if the legislation commissioning the enforcement of foreign judgments is unconstitutional, then so must the legislation commissioning the enforcement of foreign arbitral awards be unconstitutional. However, there is a big difference between a judgment and an arbitral award. A judgment is a judgment of a court of a state, and it is backed up by the coercive powers of that state. An arbitral award is effectively a matter of contract between two private parties. Not only is there that difference in terms of a fundamental difference between the nature of a judgment and the nature of an arbitral award, but arbitral awards are recognised and enforced by reason of the New York Convention. And the DIFC law, I think it's Article 44 of the arbitration law, expressly says that the DIFC court shall apply any treaties that are applicable. So we would say that the issue of arbitral awards is a separate issue, and that isn't necessarily an issue of foreign relations, in which case the DIFC court does have jurisdiction in relation to arbitral awards. But the issue in relation to judgments is a distinct and separate issue. Lord, the only point at which the claimant really engages with our argument is when they say that the enforcement of foreign judgments is not a matter of foreign affairs in any event. And they put forward as a riposte to that, they say if it were, then the court's role in such enforcement would also be reserved to the Federation. Of course, that isn't what Article 120 says. Article 120 reserves exclusive executive and legislative jurisdiction to the Federation. So it's the legislation that's being attacked rather than the role of the court.
The GIS is a common law.
Lord, yes.
And as a common law, its approach to the enforcement of foreign judgments is one which proceeds on the basis that the judgment debt is an obligation in respect of the liability established on the judgment. And that obligation can be enforced in this court, just as any other private obligation is enforced. And one might say this is a form because the affidavit confession arrangements in New York contain an acceptance by the debtor that the judgment will be enforceable outside New York in any other jurisdiction. So you have an agreement by the debtor that the judgment resulting from the affidavit of confession will be enforced in any other jurisdiction. Now what's that got to do with matters of foreign affairs?
Well, Your Honour, the argument that we make is slightly more nuanced than that. It is that the legislation that confers the jurisdiction of the DIFC court, which is understood to be Article 5A1E, Articles 24 of the Court Law, and Article 76 of the Judicial Authority Law, that is the basis on which, in the DNB case, the court has said it has the jurisdiction to recognise and enforce foreign judgments. The mechanism it employs in recognising and enforcing those foreign judgments is what Your Honour has described, is the doctrine of obligation, i.e. that the foreign judgment creates an obligation on the debtor to pay the sum in question. And that is what the court is enforcing. But that doesn't detract from the fact that if the legislation is unconstitutional, because as a matter of the interpretation of the UAE Constitution,
that's a bootstrap argument. Everything turns on the meaning of matters of foreign affairs.
Your Honour, yes.
And what I'm going to do here is that the common law approach to the enforcement of foreign judgments upon foreign analysis indicates that this is not a matter, so the argument goes against, of foreign affairs. It's a matter of the enforcement of private obligation. What could be a better example of a private obligation than this case, where your class have agreed that the judgment resulting from the affidavit of confession will be enforceable against it outside the courts of the state of New York?
Well, that is an agreement that's subject to New York law. So its validity or effect otherwise is not really of an issue before this court.
I don't understand that.
Well, we have agreed in the affidavit of confession that judgments obtained as a result of that, of filing that affidavit of confession, are enforceable elsewhere. But that agreement is subject to New York law as to whether it's enforceable or not, as to whether it has any validity or otherwise, and so on. So the fact that we agreed to that as a matter of New York law and a New York law-based agreement should not somehow confer a jurisdiction on this court to enforce that judgment.
You say that the fact that you have made the agreement you have, there's no bearing at all on whether this case is a matter of foreign affairs.
Your Honour, yes. We say that because the issue of whether or not something is a matter of foreign affairs is really about one court in State A recognising the judgment of a court in State B. And it's the fact that they're in separate states that engages the foreignness of the issue. It isn't that the court in State B is adjudicated upon private law rights as such. It is the recognition of the judgment of the court of State B in State A.
But why is the recognition of a foreign judgment where there is no treaty of reciprocity? Why is that in any way a trespass on the sovereignty of the state where the judgment was originally given?
It isn't a trespass on the sovereignty of the state where the judgment was originally given. It is an acknowledgement of that sovereignty. It is not just an acknowledgement of that sovereignty.
It is an acknowledgement of the obligation that arises out of the judgment.
But firstly, the judgment must be acknowledged as being a valid judgment. And that goes to the issue of whether or not the court had jurisdiction. And jurisdiction is plainly an issue of sovereignty of the state.
But the determination as to whether or not, in the eyes of common law, that the jurisdiction issuing the judgment, I should say the court issuing the judgment, had jurisdiction over that, is all a question for the enforcing court. It applies its own consequences to jurisdiction in deciding whether there is sufficient to treat the judgment as giving rise to an obligation to be enforced.
Your Honour, yes. Nevertheless, it does that because the question of jurisdiction is preeminently one which flows from the sovereignty of the state in which the judgment has been issued. It can only seize itself of jurisdiction based on its sovereign powers to exercise jurisdiction over people within that state, or people that submit to its jurisdiction or otherwise. So the jurisdiction recognition is a recognition of international jurisdiction that flows from the sovereignty of the other state. That, I don't believe is controversial as such in terms of the analysis underpinning the notions of jurisdiction. And it's dealt with at some length in Adams and Cape Industries, that it is an issue of state sovereignty. But here the argument is slightly different, because if one was to go to the Union Supreme Court and put to it a proposition that, look, there are all these treaties that the UAE has entered into that concern the reciprocal recognition and enforcement of judgments. are those treaties dealing with matters of foreign affairs or not? The Union Supreme Court would be bound to answer that they are. Now, if that is right, simply because they are dealt with by the exercise of a treaty power, and a treaty power is quintessentially an issue is a foreign affairs power. If that is right, then the Union Supreme Court would also be bound to answer the question whether a court acting on its own, absent any treaty, recognising or enforcing a foreign judgment, is engaging in foreign affairs. It would have to say, yes, it is. Because if the treaties are dealing with issues of foreign affairs, which they undoubtedly are, then the whole subject matter of the treaty is an issue of foreign affairs. Your Honour, it's important to remember, to bear in mind that the Union Supreme Court is a civil law court, and it is not concerned with common law principles as such. So the fact that the DIFC court is applying common law is not really relevant to this issue of interpretation. It is a pure issue of constitutional interpretation. And if those words in the Constitution are wide enough to cover the recognition and enforcement of judgments, which we say they must be, because otherwise how could there be any treaties on this subject? What are those treaties if they are not matters of foreign affairs? Then the legislative jurisdiction on the basis of which the DIFC court is recognising and enforcing foreign judgments simply falls away.
Well, I would expect the Supreme Court to take note of the legal principles which are applied in this court in respect of the enforcement of foreign judgments. And on that basis, since common law courts operate under the principles of obligation and are concerned with jurisdiction of the court issuing the judgment, only to ensure that from it, the enforcing force's point of view, there is a sound juridical basis for the personal obligation, then it would be well owed to the Supreme Court to accept that in this court, the enforcement of the foreign judgment does not involve matters of foreign affairs.
Your Honour, it may or it may not. It is a matter really for the Union Supreme Court.
Well, is there a doctrine generica that acts there?
Well, Your Honour, we would say no, there isn't. Although, to some extent, the previous reasoning that has been employed, I think by Chief Justice Wang in the DNB case, resembles that doctrine, but there is no sufficient case law. Your Honour, yes, and it's been employed with references to the European Court, and so on, where if the meaning of the European law is fairly clear, there is no need to make a reference. But we say that the meaning of this law is not very clear at all, because foreign relations are effectively, you have State A recognising and enforcing a judgment issued by State B. If we leave the courts out of the picture, the courts are simply manifestations of the state. So it is one state recognising and enforcing within its own territory the sovereign act of another state. Because the judgment of a court is as much an expression of the state's sovereignty as any other pronouncement by that state. Now that, we say, is paradigmatically an issue for foreign affairs, a matter of foreign affairs. You have two states, both independent, both sovereign. One is effectively recognising and enforcing the act of the other state. It can only do so by engaging in foreign affairs.
We're now going back to the beginning of your position. You think very clearly to not very clearly set out in your written submission.
Your Honour, yes. Your Honour, it might help at this point to have a look at Adams and Cape Industries.
Yes.
Because the doctrine of obligation is, the conceptual underpinnings of that doctrine are to some extent explored in that decision. Your Honour, that's in the Defendant's Authorities Bundle. At tab 14. If I could take you to page 553.
The report right now, not page 1. Finishes that.
I think it appears on page 85 of the...
Sorry?
I think it appears on page 85. If you look at the top right hand, in the middle, there's a... In my copy it's red, there's a 553.
How does that get into the cover?
Your Honour, if I could start at page 84,
Yes.
and it's at the bottom of the page. The judge then stated his own view as to the basis on which the English court recognises the judgment of a foreign court. Pages 491 A to B.
Yes.
And if you could read to halfway through page 85. Your Honour, in particular, we would rely on the words that the most one can say is that the duty of Hosmer's law, first identified in Shisby and Westerholz, which is the doctrine of obligation, must stem from an acknowledgement that the Society of Nations will work better if some foreign judgments are taken to create rights which supersede the underlying cause of action, and which may be directly enforced in countries where the defendant or its assets are to be found. Now, Your Honour, we would say that if it must stem from that acknowledgement that the Society of Nations will work better if some foreign judgments are taken to create rights which supersede the underlying cause of action, it is basing itself effectively on the better workings of the Society of Nations. The better working of the Society of Nations is, we would say, a matter of foreign affairs. So even underlying the doctrine of obligation is this idea that it is based on an oiling of the wheels of state power as exercised vis-à-vis each other. So to that extent, even the doctrine of obligation has at its fundamental underpinning the idea that it assists with matters of foreign affairs. And we would say it's not inconsistent with the UAE Constitution reserving issues of foreign affairs to the Federation. Just because the DIFC court is applying the doctrine of obligation, that does not mean that it's not engaging in matters of foreign affairs when it is so doing.
Well, when a common law court is applying questions of convenient form, is it engaging in matters of foreign affairs? Remember the speech towards God. On your analysis, it would be.
Your Honour, arguably, yes, it would, because all of these issues that deal between relations between courts in different states are effectively, on our analysis, matters of foreign affairs. And the fact that the DIFC court, for example, applies the doctrine of foreign non-convenience is not based on any legislation as such. So that isn't really the issue in this case, because in this case the recognition and enforcement of foreign judgments is based on legislation. It's said to be based on Article 7.6 of the Judicial Authority Law, which provides in terms that foreign judgments can be recognised, and Article 24 of the Court Law. Those are the only bits of legislation that provide for the recognition and enforcement of foreign judgments. On the back of those pieces of legislation, the Court has then employed the mechanism, if I could call it that, of the doctrine of obligation for its method of recognising those judgments, because there is no other method available to it. But that doesn't change the fact that the legislation itself is effectively engaging in foreign affairs. Or
when we finish looking at this discussion, perhaps we could go back to these statutory provisions and have another look. Take it up, I don't want to take you out of your course. Is there anything else you want to show me or submit in respect of this decision?
Your Honour, not at this stage, no.
Then, could I ask you, I would certainly find it helpful, bearing in mind the suggestions you made so far, if we could go back to the DIFC legislation, which you're referring.
Well, yes, you'll find that in the claimants bundle of authorities at tabs 19, and tab 10. If we start at tab 19, if I could take you to Article 7.6. That provides that judgment, decisions, orders and ratified arbitral awards rendered outside DIFC by any court other than Dubai courts shall be executed within DIFC in accordance with the procedure prescribed in the rules of the court. And Article 24 of the court law, which is at tab 10, states that pursuant to Article 7.4, and I think it's generally acknowledged that that should be a reference to Article 7.6, because this is pre-amendment of the Judicial Authority Law. The Court of First Instance has jurisdiction to ratify any judgment, order or award of any recognised foreign court. So those two...
Sorry to interrupt. It's probably worth reading the next sub-paragraph as well, so 24.2. Just have a complete picture. Apologies.
Just give me a moment.
Those two legislative provisions are in conjunction with Article 5A1E of the Judicial Authority Law, which is the provision that confers jurisdiction on the DIFC courts in respect of any claim or action over which the courts have jurisdiction in accordance with DIFC laws and regulations. Those three separate legislative provisions have been taken as the foundation for the DIFC court's jurisdiction to recognise and enforce foreign judgments. They say nothing about the doctrine of obligation whatsoever.
No. What's said in them? Which was the article you referred to in law number 12, which is tab 19. I'm sorry, I should have. It's article
7.6.
7.6. They should be executed within the DIFC in accordance with procedures
Your Honour, yes. Now, the DNB case analyses these provisions and the rules of the DIFC Court and finds that they are the foundation for the jurisdiction. And it may help just to have a look at that case as well at this stage.
I had something to do with that case. I've got some vague recollection. Where did you find that?
Your Honour, that's at tab 5, I believe. No,
That was my order giving to the field.
tab 8. And if I could take you to page 27.
Yes.
Paragraph 102, Chief Justice Fung quotes Lord Bridge in Owens Bank and Bracco, and he sets out the doctrine of obligation.
Yeah.
And he then goes on, in my view, this is founded on the concept of international comity, which connotes courtesy or the need for reciprocity between foreign courts. So even in the DNB case, the Chief Justice is recognising that the doctrine of obligation is itself premised on notions of comity or reciprocity. Notions of comity are effectively based on what is perceived to be an international law, a rule of public international law, that judicial systems must respect each other. Now, again, because it is a rule of public international law that underlies that notion, we say that it must be a matter of foreign relations. Again, it's about the relations between two sovereign states. So the interposition of the courts makes no difference to that relationship. The courts are simply, as I've already said, an emanation of the state. So, Your Honour, we say however one looks at the position, underlying it all is a matter of foreign affairs. And that is certainly, we would say, not just arguable, but seriously arguable. And it is an issue of the interpretation of the UAE Constitution as to whether or not the words foreign affairs, as used in that Constitution, extend to this particular type of activity.
Common law over the century has adopted and synthesized broad general principles from a whole range of different sources. Your master's judgments were informed very much by civilian principles. And the is in effect a common law principle whose origins ultimately go back to broad principles of universal law. You see, it's very much set against that there's a world of difference between these common law principles. For instance, foreign law and what is captured by the wording of the Constitution, matters of foreign finance.
Well, Your Honour,
It does seem to me that what you're submitting is capable of undermining entirely the application by this court of those principles of law which have their origins in ancient principles which had regard to the relations between states. At the moment, I'm yet to be convinced that there is any difference to be made on your position between the enforcement of a foreign judgment and the application of the doctrine of foreign law. Never, you would not admit, would you, that this court does not have jurisdiction to apply the doctrine of foreign law?
well,
Or would you?
Your Honour, I don't need to submit that because
We are engaged here in an important dilemma. We've got to explore where your submission should go. I want to space up to this proposition. Do you say, do you accept that the submission you're making effectively undermines the jurisdiction of this court to apply the doctrine of foreign law?
Your Honour, I don't, and the reason I don't is simply because that is not a doctrine that is based on legislation or executive action. And it is only the legislative and executive jurisdiction that is exclusive to the Federation. So to the extent that there is some judicial jurisdiction that is separate from that, that is not affected by the UAE Constitution. However, I go back to the point that in this case, the foundation of the jurisdiction is legislative.
And that makes all the difference in your position.
Well, Your Honour, yes it does, because it is an exclusive reservation of that legislative jurisdiction to the Federation, which is a constitutional mandate. The Constitution is the highest law that is applicable in the Emirates, including in the DIFC and in Dubai. And it simply cannot be ignored because of the general workings of the common law. At the very least, the matter should be referred to the Union Supreme Court for its view.
But you showed me those passages in the Chief Justice's judgment that echo the reasoning in the previous case you took me to. Is there any other position that we should take in respect of the DND case?
Your Honour will have seen from my written submissions that we don't necessarily accept that the DNB Bank case properly analyses the doctrine of obligation, or that it is in any case a binding judgment, in the sense that the findings of jurisdiction are, we would say, obiter, insofar as they were not necessary for the decision of that court. And at paragraph 98, the Chief Justice makes that quite plain, because he says, nonetheless, Articles 74 to 76 of the JAL do not apply in this matter. He's dealing with an appeal on Article 72 of the JAL, and not on Articles 74 to 76. So he doesn't actually decide those matters at all. He expressly says they do not apply in this matter. So to that extent, the discussion on issue 1, which precedes paragraph 98, is effectively obiter. And one is then faced with the DNB Bank case in first instance, in which the findings were made that these are the foundations of the jurisdiction. But turning to that discussion at page 25, we do also say that there is something underlying it which is somewhat confused, because not only does the learned Chief Justice treat Article 76 as being one of the enactments referred to in Article 5A1E, and we say that that simply cannot conceptually be, because the enactment must be a separate enactment from that which contains Article 5A1E. But he also effectively confuses enforcement with execution. The statutory wording relates to execution. It doesn't relate to enforcement at all. And enforcement and execution are two quite separate things. Execution is actually putting into effect the mechanisms needed to enforce a judgment, whereas the recognition and enforcement of a judgment is actually saying that it is enforceable. It may be a fine distinction, but it is nevertheless a distinction that is there in the law.
If a law confers on a successful litigant in following litigation the right to execution in respect of that judgment, implicitly that judgment is to be recognized and enforced.
Your Honour, yes, but the way that the two processes are separate, because firstly, if you're recognising and enforcing a foreign judgment, particularly under the common law, there has to be a separate action brought on that judgment, which is then becomes a judgment of the court that's issuing that judgment, which is the mechanism by which it's enforced. That's not the mechanism by which it's executed, however. And likewise, under the civil law system, where you register a judgment, it is the registration of the judgment which gives it the force of enforceability in the civil law jurisdiction. That has nothing to do with execution. So if one is left then, if one discounts Article 7.6 from being the enactment that Article 5A1E refers to, one is left in Article 24 of the Court Law, which we were having a look at earlier. Now that speaks in terms of the ratification of a foreign judgment. It doesn't, again, speak in terms of the enforcement or the execution of a foreign judgment. Now, we would say that it's simply beyond the realms of imagination that the process whereby you bring an action on a foreign judgment and have in an independent, separate action in the court in which that action is brought, a separate judgment, which then is effectively enforcing that judgment, can somehow constitute ratification of that judgment. Ratification is a word that is used for an administrative approval, effectively, and not for this process whereby an independent action is brought, is fought out, and is then results in a separate independent judgment. So, again, we would say that that is not apposite to import the doctrine of obligation into the DIFC courts. Article 24 also refers to the foreign court being recognised. Now, again, the decision in the DNB case effectively skirts over this point and doesn't really answer the question of recognised by who or for what purpose. Now, the language of recognised foreign court is reminiscent of the 1933 Recognition of Judgments Act from England, where, again, by order in council, a foreign court can be recognised such that its subsequent judgments are then registrable under that act. So the fact that the statute in the DIFC uses that word, recognised, really we say begs a question which has not been adequately answered by the DNB case. So for these reasons we say that the reasoning in the DNB case is in any case flawed. Well, there's one further document that I'd like to show you.
Yes.
And that is the Gennard report, which I think you'll find at the very end of the Defendant's Authorities Fund. tab 24, I believe.
Yes.
Your Honour will be familiar with the context of this report.
Yes.
And in chapter 1, on the second page, sorry, the third page from the beginning, it recites, the fact that the Treaty of Rome requires the Member States to resolve their problems shows that it is important. In a note sent to Member States on 22nd of October 1959, inviting them to commence negotiations, the Commissioner of the European Community pointed out that, and if I could take it from about halfway through that paragraph, as jurisdiction in both civil and commercial matters is derived from the sovereignty of Member States, and since the effect of judicial acts is confined to each national territory, legal protection and hence legal certainty in the common market are essentially dependent on the adoption by the Member States of a satisfactory solution to the problem of recognition and enforcement of judgments. Again, we would say that that underscores the idea that recognition and enforcement of judgments is a matter of foreign affairs.
Well, that's dealing with jurisdiction of a court, firstly making a determination in question. And clearly, the assertion of jurisdiction over individual entities recognized in the legal system is an act of sovereignty. So, for instance, the courts of the state of New York, their assertion of jurisdiction over your clients were at bottom an exercise of the sovereignty of that state. But does it necessarily follow that the recognition of a judgment, which is ultimately the result of an exercise of sovereignty of the state within which the original court is located, is itself concerned with, for the purposes of the UAE Constitution, matters of foreign affairs.
Well, we would say it does follow, because the judgment is itself territorially limited until it is recognized by the other state. So, to the extent that you are recognizing, for example, the legislation of another state, that has to be a matter of foreign affairs. It is no different. If the DIFC were to incorporate into its legislation English law as English law, that would surely be an exercise in foreign relations.
But to some extent it has done that. There's a waterfall provision which you're probably familiar with as to what are the applicable rules of law in cases brought before this court. And the last stage of the waterfall is the law of England and Wales.
Your Honour, yes, that's correct. But that is something that the DIFC law is expressly providing for. The position I'm putting is slightly different, which is that if, for example, India was to say tomorrow that English law applies in India as English law, that would be a matter for foreign relations. Because there is no basis for English law applying in India as English law. Only Indian law can apply in India. If the Indian law says that the English law will apply as Indian law, then that is a different matter. That is adopting it as being Indian law. But if it is adopting it as English law, it is basically recognizing the legislation of another sovereign as applicable within its own territory.
I don't know how all this goes. It's common that in cases involving the competences of laws, that an English common law court will apply the law of a foreign state as the applicable laws of the case. Does that fall foul of Article 124?
Your Honour, it doesn't, because the application of applicable law is a conflict of law rule that is based on the choice of the parties.
Well, not necessarily. But anyway.
Your Honour, if I could take you to page 8 of the General Article. Chapter 3, Scope of the Convention.
Yes.
Little point 1, International Legal Relationships. In the second column, it says, it is clear at the recognition and enforcement stage, the Convention governs only international legal relationships, since ex hypothesi it concerns the recognition and enforcement in one contracting state of judgments given in another contracting state. Now, again, in our submission, what is there being said is that ex hypothesi, the recognition and enforcement in one contracting state of judgments given in another contracting state is a matter for international legal relationships. And to the extent that international relations are commonly used as an alternative expression to foreign relations, which is used as an alternative expression to foreign affairs, we would say that is an express acknowledgement by the learned author of this report that recognition and enforcement of foreign judgments is a matter of foreign affairs. If I could take you now to tab 22, Your Honour.
Yes.
This is an extract from a work by Campbell McLaughlin entitled Foreign Relations Law. And at paragraph
Can you tell me something about Mr. McLaughlin, Mr. McLaughlin?
Your Honour, I'm afraid the front page of the extract has not been copied. As I understand it, Mr. McLaughlin is a well-known public international lawyer I'm not sure where he teaches, but he is an academic.
Yes. Do you think one of your team could provide me with a photocopy of that early part of the book?
Yes.
Give me his position. So,
Of course.
thank you very much.
Now, at paragraph 12,
Did you say paragraph 12?
Your Honour, yes, it's page 14 of 143.
We're still in tab 22.
Tab 22, Your Honour, yes.
Sorry, I'm being very slow. Paragraph 12 to also that I see. So there's a section headed applicable law of foreign state. Is that what we're looking at?
Your Honour, yes, it's the second page of that section.
Second page. Yes.
Your Honour, just at the bottom of that page, he says, this point serves to emphasise the three central propositions of this work as a whole, namely that A, foreign relations issues are capable of regulation according to law and are not excluded from legal regulation, but B, a central question in such cases is that of allegation, or choice of jurisdiction and choice of law, i.e. whether the case or issue is properly regulated in the courts of the forum and according to its law, or by the law of the foreign state. So, Your Honour, I rely on that as, again, making good the point that simply because something is the subject of a conflict of law rule doesn't mean it isn't part of foreign relations.
Yes.
You're on page 16 of 143.
Yes.
The author deals with, you'll see at paragraph 12, 142, enforcement of foreign judgments in this context.
Yes.
Paragraph 12, 143, having referred to the UCOS and Rosneft case, he says, these points are important for what they say more broadly about the real operation of the active state doctrine in private international law cases. The private international context fundamentally alters the nature of the question. Where the foreign state itself sues or is sued, then, judged according to the standards of public international law discussed throughout this part of this work, there can be no distinction between the acts of any of its organs. There is only one entity with legal personality. But where the questions are ones of private international law, the determination of jurisdiction, applicable law, and enforcement of foreign judgments, the acts of the foreign state have to be disaggregated in order to address the specific questions posed by the private international law rules of the forum. He then goes on, the acts of the foreign legislature may have to be assessed for their constitutionality, The acts of the foreign court may need to be assessed in order to determine whether jurisdiction can be declined and whether the foreign court's judgment can be enforced. Again, we rely on that passage, Your Honour, as reflecting that, notwithstanding the private international law context, these matters nevertheless remain matters of foreign relations or of foreign affairs.
Well, you specifically see here the scope of the contract state.
Your Honour, yes, and we are not saying that a foreign judgment is an act of state within the act of state doctrine. But what we are saying it is an act of state in the conventional understanding of that word. But the doctrine itself is a specific doctrine that is limited to certain types of acts.
Which act of state is it the beginning of the original judgment, or is it the enforcement of the original judgment?
Well, both we say are acts of state in the sense that they are acts of a court of the state. Well, to the extent that the court may think that the doctrinal obligation can apply as a common law doctrine, regardless of any statutory underpinning, then we would say that risks not just this court usurping the powers reserved in the UAE Constitution to the Federation, but it also risks the danger of the judiciary and the executive not speaking with one voice. And the one voice principle is a well-known one as a matter of English law. I won't take your honour to the cases, but in the Aaron Sasu Mendy, Lord Atkin famously said, our state cannot speak with two voices on such a matter. The judiciary saying one thing, the executive another. And we would say that is important in this case because the executive, assume that the DIFC court were to legislate in such a way as to act contrary to a mutual recognition treaty. Assume that the Dubai government were to legislate in such a way that empowers the DIFC court to act contrary to an international treaty that has been entered into by the UAE. Now, that would plainly be unconstitutional legislation.
Yeah.
But on my learned friend's argument, there would be nothing wrong with that, because there would be no constitutional bar on that legislation. Because he would say that that's a civil and commercial matter that is exempted from the federal laws by Article 121 of the Constitution, and it is plainly within the Dubai government's powers to legislate in that way. Now, we say that that simply can't be the case. The executive and the judiciary, including the DIFC judiciary, must be seen to be speaking with one voice. And to the extent that that may follow from Article 121, Article 121, of course, begins with the words, without prejudice to the preceding article. So the list of matters reserved to the Federation in Article 120 is paramount. they simply cannot be derogated from. And Article 121, with its exception for financial free zones and individual emirates creating the law in the financial free zones, cannot derogate from Article 120 at all. So to the extent that something is foreign relations within Article 120, the exclusive legislative and executive jurisdiction in respect of that remains with the Federation.
Well, it all comes back to Article 120.
Your Honour, yes, it does. And we don't shy from that. And we say that
On the contrary, you erect the whole emphasis of your argument on it.
precisely.
Yes. You say that when this court enforces a foreign judgment, that is a matter of foreign affairs. That's really the beginning and the end of your argument. For the reasons you've very skillfully and attractively presented.
Your Honour, yes. And we say that that is not only in accord with common sense and the common use of language, but were it not for common lawyers versed in the doctrine of obligation, there wouldn't be any question about it whatsoever. You would say, look, this is one state, the court of one state, recognising and enforcing, giving the coercive power of this state to the judgment of another state. That has to be a matter of foreign affairs. What else could it be? It is nothing to do with the private rights of the individuals whose obligations inter se are being determined by that judgment. It is the recognition of that judgment as a judgment. And on that basis, we say that the matter is plainly referable to the Union Supreme Court. Because to some extent it's an impressionistic point, but it's plainly one where opinions can vary. And if the opinion that I'm expressing is the correct one, that would of course have very dramatic consequences for the DIFC courts. And it's better that this matter gets referred now, before there are many, many judgments enforcing foreign judgments, which may then turn out to be unconstitutionally done. Then subsequently, well, Your Honour, to some extent it is, but the power to refer matters to the Union Supreme Court is not simply vested in private law cases brought by applicants to a court. It is also vested in the authorities of the Emirates and in the authorities of the Union. Now, at some stage, because of the importance of this point and its importance to the wider Emirati legal community, we say that it's almost inevitable that that sort of reference will be made.
Does your argument go as far that the onshore Dubai courts would have no jurisdiction to enforce them?
Well, the onshore Dubai courts are, of course, applying Article 235 of the Civil Procedure Code, which provides for recognition and enforcement of foreign judgments purely on the basis of reciprocity. Now, that is legislation of the Federation. The way in which the Dubai courts are coming to apply it is we say neither here nor there. The fact is the legislation is constitutional because it is legislation issued by the Federation. So there is no issue about the constitutionality of Article 235. But that is how the onshore courts in Dubai will deal with the matter. And that, of course, we say is a matter for them, and not a matter that this court should necessarily concern itself with. think we are pretty much.
Well,